So, when you think about the American justice system, what comes to mind? Probably a dramatic courtroom, right? A passionate lawyer, a jury hanging on every word. Well, what if I told you that's basically a myth? Today, we are pulling back the curtain on the real engine of American justice, plea bargaining.
And it all starts with this number, 90%. Get this, scholars estimate that at least 90%, and maybe even higher, of all criminal cases in the U.S. are resolved with a plea bargain, not a trial. It's an absolutely staggering figure. Which leads us to the big question we're tackling today. How on earth did we get to a point where 9 out of every 10 people accused of a crime gives up their constitutional right to a trial? What is going on here? Let's get into it. You know, we're all trained by TV to think of trials as the main event, but the reality? Plea bargaining is the system's default setting now. It's just how things are done. And as one law professor, Carissa Byrne-Hessick, puts it, this whole system operates in a near-lawless fashion. Why? Because all our legal rules were written for a world of trials, not for these backroom negotiations.
And right away, you hit the central debate that legal experts are wrestling with. Is this system a necessary evil, something we need for efficiency? Or is it a genuine threat to the idea of justice itself? You've got compelling arguments on both sides.
So let's start with the main argument for plea bargaining. It's pretty straightforward. Our courts are completely overwhelmed, and this is the only thing keeping the gears from grinding to a halt. The whole argument really boils down to pragmatism.
And John Flynn, who was president of the National District Attorneys Association, really lays it out there. He basically says, look, especially after the pandemic, the backlogs are so insane that if we got rid of plea deals, the entire system would just stop. From that point of view, it's not a choice, it's a survival mechanism.
But then, you get this incredibly powerful counter-argument. Angelica Hendricks from the Quattrona Center says we shouldn't call it judicial efficiency. We should call it judicial deprivation. Her point is that people are being pushed to give up so many of their fundamental rights that we have to ask, are these guilty pleas even truly voluntary anymore?
Now, here's where it gets really interesting. Professor Jeffrey Bellin suggests we might be asking the wrong question entirely. Instead of asking if plea bargaining is good or bad, he says the real question is, compared to what? He argues that a lot of the time plea bargaining isn't the cause of the problems, it's just a symptom of a system that's already broken in other ways. So if the system is designed to produce pleas, what's the actual mechanism? What pushes so many people to take a deal? Well, critics say it comes down to one overwhelming factor, the terrifying risk of actually going to trial.
And that brings us to this absolutely crucial concept, the trial penalty. Okay, imagine this. You're offered a plea deal for, say, 3 years in prison. But the prosecutor tells you, if you reject this deal, exercise your constitutional right to a trial, and you lose, you're facing 20 years. That huge gap, that chasm between the plea and the potential sentence, that's the trial penalty.
And it's all about framing, right? As you can see here, prosecutors might call it a plea discount, a little reward for saving everyone time. But critics see it as a trial penalty, a punishment for daring to use the rights you're guaranteed by the Constitution. It's two sides of the very same coin, describing the exact same choice. To really wrap your head around just how powerful this pressure can be, Professor Bellin uses this incredible historical example. Think about the Salem witch trials. People confessed to being witches. Why? Not because they were guilty, but because confessing meant they lived. Insisting on your innocence meant you were executed. When the alternative is that terrifying, even an innocent person might confess. But hey, it's not just the trial penalty. There's another huge factor at play here, and that's pretrial detention. You simply cannot talk about plea bargains without talking about bail. Because whether you're fighting your case from home or from a jail cell, well, that can change everything. And the data, it totally backs this up. Research found that defendants who are locked up before their trial are a whopping 25% more likely to plead guilty than similar people who are released. Think about it. If you're in jail and a prosecutor offers you a deal for time served, meaning you get to go home today, that's an offer that's almost impossible to refuse, whether you're guilty or not. Okay, so given all these deep systemic issues, is the whole thing just broken? Is there any hope? Well, according to some experts, yes. They're actually proposing concrete, practical reforms that can make the process a lot fairer.
Professors Hessick and Fogel say that judges don't have to be passive bystanders. They have real power. So, for example, a judge could refuse to accept any plea deal until the defense has seen all the evidence. Or, with those time-served offers, a judge could release the defendant first so they can make the decision without the pressure of being locked up. And finally, they could add some real teeth to the rules with actual consequences if prosecutors miss deadlines.
And this really gets to the heart of Professor Hessig's argument. She says judges need to rethink their role. A plea bargain isn't just some private agreement between two lawyers. It's a court order. It's a judge using their power. And if you're going to use that power, she argues, you have a responsibility to make sure the process is actually fair.
And this whole situation has massive consequences for all of us. Professor Hessig calls jury duty a retail moment for democracy. It's one of the few times regular citizens get to participate directly in how our government works. When trials disappear, we lose that. The justice system becomes more isolated, less accountable to the very people it's supposed to serve.
Which leaves us with this final, really important question. The whole idea of American justice was built around a public trial by a jury of your peers. But we've just seen that for 90% of cases, that's not our reality. So we have to ask ourselves, if juries are democracy in action, what does it mean when almost all of our justice is handed out in secret, behind closed doors?